Good to be here once again. So today we are going to be discussing the issue of appeal commenced, and not just the preliminaries of how to commence an appeal. I'm also going to maybe touch some other areas in appeal that would be very helpful to us because an appeal is, let me say, a school in its own. So if we start talking about the entirety of appeal, it's going to take as many weeks as possible. So for the purposes of syllabus, we are going to limit ourselves to certain things that you need to know, the certain basic things that you need to know concerning appeals. All right. Now, first of all, you want to know the meaning of an appeal, what an appeal is, what is it all about. So from there, we'll proceed. So we'll talk about what is an appeal. Appeal is simply just like the way it sounds. Appeal is just like when you are pleading with somebody. When you are begging, maybe you're begging somebody or begging an authority. These are the common sensical approach to it, the common man's view of it, or the layman's approach that will help us to understand it before we now begin to look into the legal nitty-gritties. Now, to appeal simply means to beg, to ask for something, to ask for a review. Something has been done and you are aggrieved with what has been done. And then you are appealing, you're maybe appealing to someone else who can help you solve your problem. Let's say, for instance, you have a problem, you have approached Mr. A, and Mr. A is not in a position to help out, and you believe that going to Mr. B, who is higher than Mr. A, possibly in the hierarchy, if you're talking about something that has to do with hierarchy, and then you believe that Mr. B will hear you out and then possibly solve your problem. So the same approach is what the legal appeal process look like. It is a situation whereby somebody who is dissatisfied with the judgment of a court appeals to the higher court, that's the appellate court, for the purposes of having the appellate court to review the decision of the lower court, either with a view to setting it aside or giving judgment in your favor or ordering a retrial of the matter. So this is what an appeal looks like. So an appeal, strictly speaking, is not an entirely a fresh case, a new case. No, it is rather the continuation of the matter that had been determined at the lower court. But continuation in the sense that the court with the higher authority, now the appellate authority, will review the decision of the lower court to find out whether the lower court was correct in its decision or whether something was amiss with the decision that one person or the other party is aggrieved. That is, the appellant is aggrieved. So this is the nomenclature of the legal appeal, what it means to appeal to an appellate court. Now, the person appealing is known as the appellant. The person who is appealing is known as the appellant because he's the one who lost the case at the lower court. While the person who won the case at the lower court is described as the respondent. Is described as the respondent. So, if for instance it was the claimant that won the case on appeal, that means when the matter goes on appeal by the defendant, he is called the defendant appellant, and vice versa. So if it was the defendant that won at the lower court and is the claimant that is appealing, so the nomenclature changes. The claimant becomes the claimant appellant, while the other defendant becomes the defendant respondent. So when we talk about, by the time we start talking about the structure of parties You see also something different how the names are going to be juxtaposed, because the person who is appealing will be the first person whose name will appear there, just like we have the claimant being the first person appearing on a writ of summons when he is suing. So when an appeal is being filed, it is the person appealing that whose name comes first, and then the others they are then regarded as the respondent. So before going ahead to talk more on appeal, I want to look at a legal authority that will help us to know the purpose of appeal. Purpose of appeal. And that's going to be Okoli and the State, Part 2023, 1894. Okoli and the State, 2023, Part 1894, page 1. Okoli against the State. So let's look at what the purpose of an appeal is stated to be. And this is another Supreme Court decision. Remember, I said that we're going to be relying more on Supreme Court decisions in this our series of discourse. So in this case, Okoli against the State, the Supreme Court made us to know the purpose of an appeal. And the Supreme Court states here that the purpose of an appeal is to show that the concurrent findings of facts on the evidence are wrong, and not to set up an alternative view on the evidence without faulting the reasons of the concurrent decision. I'm also going to explain that. And then the Supreme Court compared it to the facts of the case and said, in the instant case, the appellant failed to show that the concurrent findings of facts by the lower courts were perverse as to make the Supreme Court set aside the same. Now, talking about the purpose, you have had a word that requires interpretation here, a concept that one will need to define and tell you the meaning. And this is talking about concurrent findings. Now, if, for instance, a matter is lost at the magistrate court, and the party that lost the matter is desirous of appealing to the high court, you don't talk about concurrent findings. If the decision was that of the high court and a party has lost in the high court, you don't also, and you're appealing to the court of appeal, you don't talk about concurrent findings. Concurrent findings simply means the findings of the court of record and the court of appeal. In other words, either the findings of the High Court and the Court of Appeal, Federal High Court and Court of Appeal, National Industrial Court and that of Court of Appeal. When they synchronize, when the decision of the High Court, or Federal High Court, or the National Industrial Court is upheld by the Court of Appeal, these two decisions are called concurrent findings, which means the party that won at the lower court has also won at the Court of Appeal. And should there be any need to appeal further to the Supreme Court, this party that wants to appeal now is more or less facing the task of showing the Supreme Court how the decision of the lower court and the decision of the Court of Appeal were all wrong. In other words, two decisions combined, that's the concurrent findings. But if you're appealing only against the decision of a high court, you're not talking about concurrent findings. So I had to explain this concept so that we understand why the Supreme Court used that word, concurrent finding. So what to take home here is, let's assume that we are substituting the decision of a high court here as that of a lower court that is being appealed against to the Court of Appeal. So we can say the purpose of an appeal is to show that the findings of the lower court or the findings of the trial court on the evidence is wrong. So that's the purpose of appealing against any decision of a court, and not to set up another case entirely. not to set up another case entirely. Just like I did say when we are talking about the decision of what an appeal is, you are begging, you are soliciting. Though let me not actually, I'm using the word begging in a loose term because appeal is a constitutional right. So you don't have to beg for it. It is your right. You don't have to beg for it. So it just the simple language that I want to use so that we can understand it is just akin to somebody who is begging, who is making like a prayer, who is making a request for a review. Please consider what A has done to me with a view of condemning the act of A against me. That is an appeal. So that is the kind of impression that an appeal ought to give you so that you understand it better. All right. So we'll look at some further authorities by the time we start talking about the components of appeal itself. Now, having discussed, having understood the meaning of an appeal, the next thing we have to do now is to ask ourselves, how does one commence an appeal? How is an appeal process commenced? How is an appeal process commenced? I will give you a rundown, then I will come back and explain them one after the other. So the first thing I want to say here is to once you lose a case, let's use you for example now. You lose a case and you are dissatisfied. You want to appeal against it because you believe that the decision of that court was wrong. So the first thing you need to do is to file what is called notice of appeal. Notice of appeal. We are going to later talk about the contents of notice, what a notice of appeal is, and its contents. So that means I'm going to come back to that again. So you file your notice of appeal. As soon as you have filed your notice